Hi, I'm Susan Lipp, Editor-in-Chief of Trust and Estates, and I'm here today with Sharon Klein, who is the Managing Director of Family Office Services and Wealth Strategies at Wilmington Trust. Sharon has written an article for Trust and Estates called The State of the States. Sharon, in your article, you focus a lot on posthumously conceived children. How do the different states handle that issue, and how should those children be treated for inheritance purposes?
Well, that's obviously a very good question, and how the states handle the issue depends on their view of how these children should be treated for inheritance purposes. A posthumously conceived child is a child that's born after the death of one or both of the child's genetic parents as a result of using genetic material that was stored before death. And the fundamental issue, the heart of the issue, is how to balance the interests of these afterborn children with the interests of existing beneficiaries in finality and certainty. You don't want to keep an estate open indefinitely because of the possibility that there may be an afterborn child. On the other hand, you don't want to close an estate prematurely if there is in fact a child born. So right now, by my count, there are 18 states that have legislation specifically addressing posthumously conceived children, with 2 more states having legislation pending. The vast majority of those states do give inheritance rights to posthumously conceived children if they fall within certain circumstances. 9 of the states of the 18 have enacted a form of the Uniform Parentage Act, which basically provides that a child born after the death of a parent won't be considered the child of that parent unless the parent had specifically consented in writing to the posthumous reproduction. Some of those states and some other states that have enacted their own legislation also have time limits within which an afterborn child must be conceived and or born. The shortest I've seen is that such a child must be born within a year of the death, and the longest is 45 months, which, you know, depending on how quickly you get over a death and how successful these technologies are, 1 year can be very short, and even 45 months can be on the short side. But again, it's an attempt to strike a balance.
Right. Well, it sounds like this whole area is in a state of flux, so how should advisors be approaching their clients on this issue?
That's a very good question, because I think the best way to approach the issue is to raise it. Because many people don't focus on this issue if they themselves aren't using assisted reproductive technology. It's easy to think, I've had my children, or I'm past childbearing age, it doesn't apply to me. But in fact, if you create long-term trusts, dynasty trusts, set up to last for successive generations of your issue, it may well apply to you if your children or grandchildren take advantage of these technologies. So I think that people need to focus on how do they want to define it within their own documents. And the issue really came into practical consideration in a very recent case, just a few years ago in New York, in Re Martin B. It's actually the only case that I know of decided in the country that addressed the distribution rights of posthumously conceived children in trust. The other cases have turned on the entitlement to Social Security benefits of posthumously conceived children. But this case was interesting on a number of fronts, including that the decedent who stored genetic material and whose wife had 2 children born after he died, that decedent hadn't created the trust at issue. It was his father who created a trust in the 1960s, and the question was, were these afterborn children considered issue of the grandfather and entitled to a distribution from the trust? And the surrogate found, under the circumstances of this case, that the children were entitled to inherit, but had to look at the presumed intent of the grandfather who created this trust in the 1960s, when these technologies couldn't even have been contemplated. So the finding is really limited to the specific facts of the case, and the surrogate actually called for comprehensive legislation to address these issues, because it's a little ironic to go on this search for a presumed intent of a settlor who we know never thought about this issue. So I think the best way to deal with it is to deal with it in our own documents. Important, very important, if you live in a state that doesn't have legislation, because the law is very unclear in this context, And even if a state does have legislation, it might not be what you want.
Mm-hmm.
So the beauty of doing it in your own documents is that you could do what you want, define time limitations, consent requirements, and make sure that your intentions are carried out as you envision them.
Mm-hmm. Oh, wow, thank you. I mean, I just think this is such a fascinating issue.
Yes.
And you could read Sharon's entire article in the November issue of Trust in the States.